The Supreme Court has ruled that the peak wage system is against the law without a reasonable cause or criteria supporting it, even if the rule was introduced through agreement by labor and management. The ruling indicates that without the presence of corresponding measures such as lighter workload or extended retirement age, slashing wage levels based on one's age is discrimination.
The Korea Electronics Technology Institute introduced the peak wage rule in 2009 as agreed upon by the labor union. One employee, whom we'll call A, was subject to the rule from 2011 when he turned age 55. His monthly salary went down by as much as 2.8 million won, but there were no changes to his daily obligations or intensity of work. Basically, he only saw a wage cut with no compensation such as an extension in retirement age. This employee filed a lawsuit arguing such age-based discrimination is unjustified. Under the Elderly Employment Promotion Act, discriminating against wage levels on the basis of age alone is prohibited if without a valid reason. After a 5-year deliberation, the Supreme Court has sided with the plaintiff. The court said the peak wage scheme was discrimination, pointing out that while the company introduced a rule to save labor costs, it did not seek measures to address disadvantages suffered by the employees.
대법원이 제시한 기준을 충족하지 못한 채 임금 피크제를 시행하는 회사의 경우 고령자에 대한 적정한 대상 조치를 취하거나 기준에 맞게 임금 피크제의 내용을 수정해야.
The plaintiff will now get back some 130 million won in reduced wages from past years. The top court noted that if the peak wage rule is to be valid, companies should have introduced corresponding measures such as extended retirement age or lighter workload. They should also be responsible for using the saved costs for intended purposes.
감액된 그 부분만큼 신규 근로자를 채용한다거나 아니면은 기존 근로자들 임금 피크제 관련된 재원으로 사용되는 데 주목해야 돼.
The latest ruling serves as a warning against resorting to the peak wage rule only for corporate profitability.